But at least under President Trump's view, he's invoking that law, which grants the president the power to declare an emergency and then place limitations and regulations on American trade. So it's part of, I think, a broader trend in American politics, especially across the 20th century, in which Congress has preferred, oftentimes for reasons of efficiency, to delegate its legislative authority to the executive branch.
This is CBS Eye on the World. I'm John Batchelor. It's a great pleasure to visit with John Grove, who has an essay, Mr. Grove, in a recent issue of Civitas Institute's Civitas Outlook, celebrating this time of year, April of 1775. It is an anniversary of types to the men and women of 1775 who rose up against the greatest navy and army in the world and were successful. And here we are today puzzling why it is they rose up, they took those risks. Remember, only a third of the people at the time were in revolt from the king. A third of the people were loyal to the king, and a third wandered around in between. Sound familiar? Well, that was then. However, I come to why it is they rose, and it connects amazingly with the events right now. The disorder and the turmoil in the world markets and in the political conversation of the United States. John, a very good evening to you. Thank you for this. I go to one little phrase that we all have from childhood, I believe, when we were learning first about the revolution. And that was the reason the colonists revolted was no taxation without representation. Is that the correct reason? Do I say it correctly? And was that all of it? What did it mean to them? Good evening to you, John.
Good evening. Thanks so much for having me. Yes, I think it is accurate, but it's part of a broader context that's important to understand that broader context and not just take that sort of nice pithy phrase completely on its own. And the broader context, I would say, is the context of constitutionalism. When they cited that principle of no taxation without representation, they were citing a basic principle of the British Constitution and a right that they felt that they held as British subjects. And so when the tax controversy started in the 1760s, the colonists weren't just offended by the tax itself, but they were offended by the principle that was being forwarded by Parliament, and that was that the Crown in Parliament, which was in England was increasingly seen as the central hub of political power, that it had the power to pass any laws and taxes for the entire empire that it deemed to be necessary. And the colonists had a very different understanding of the imperial constitution that they lived under. They held that they had lived for decades, close to a century, and for a century for some of them, with their own colonial assemblies, and that their own colonial assemblies that's where the people of their colonies were represented, and that those colonial assemblies possessed the power to tax. And so the Parliament's claim to be able to tax and legislate for the colonies to them sounded like arbitrary power. It sounded like power that was breaking out of all of the constitutional institutional limits that they had taken for granted. And it was that increased sense that there was no consensus over what the Constitution was that they were living under that really helped make that break become turn to a break on pointing to independence and not just a revolt.
In your article, you cite the historians Jack Green and John Philip Reed talking about the constitutional anxieties of the moment. Constitutional anxieties, they didn't have a written constitution, so what did that refer to?
Right. So at the time, their notion of the Constitution was highly customary. So it had a lot to do with how things had been done for a long time. And so specifically, that constitutional question about taxation, from London's perspective, that principle of no taxation without representation was essentially shorthand for saying that Parliament must tax, right? Because Parliament was the representative assembly. So from London's perspective, that empowered Parliament, but the colonists had a very different experience, and so the custom and the experience they had lived under was that their colonial assemblies were the representative assembly. So when we talk about the imperial constitution, right, it is a lot about experience and about long-standing practice and long-standing precedent. And so eventually, when you had two people separated by an ocean and having a somewhat different experience of the British Constitution, right, they naturally sort of developed different ideas about what that was. But to the colonists, at least, Parliament's claim to have the same authority over them as they have over people in England was a violation of the way they had been governed for a century.
The way I read you, John, is that this all comes together not about taxes, but about law, the rule of law. So you're making the case that the revolt was about maintaining the rule of law, that is, a government of laws and not men. And the objection was the way Parliament was applying its power, it was not only whimsical, it was whatever they said it was, and they were whatever the king said. Is that did they talk like that in the colonies?
Right. That is, I think, the sort of the Patriot case centered around that for all of the specific instances, the specific laws that they took issue with. I think they all tended to revolve around that question that they sensed that Parliament was asserting lawless power, power to make and remake laws. So eventually, as things developed, Parliament passed laws that influenced the internal governance of the colonies, changed their governments. One of the laws that really stuck out in the colonists' imagination that we don't really talk about all that much today is the Quebec Act, and that structured a government for Quebec. And in doing that, Parliament granted granted a lot of the sort of customary ways of governing for Quebec, which had more of the French tradition. But for the colonists, they looked up there and they saw a government for Quebec that had been established without a representative assembly and without a lot of the protections of the British common law. And so when they saw that law, that establishment of a government in Quebec along those lines, what they saw was Parliament feeling like it has the authority to create whatever governments, create whatever establishments it decides is appropriate, and that Parliament is not bound by those sort of prescriptive elements of the British Constitution, namely that a British subject has the common law as their protection, a British subject has a representative assembly, and so forth.
When we come to 1774, that's the Continental Congress first forms. And John Adams attends, and we have at length his attendance. But you point to something called the Fairfax Resolves of 1774. What were those, John?
Well, they were drafted in Virginia by George Washington was one of the primary writers of those, and they were just one of a series of um, they're one of a series of many petitions that the colonists put forward, trying to articulate clearly their objections in hope of finding some reasonable discourse around what could be around finding a reconciliation and reasonable settlement of the disputes.
So that's when Jefferson gets involved with some review of the rights of British America. They're already separating themselves from Parliament and stating these are our rights, and they were not being honored. I presume that that was the first time they examined the possibility that they were living under a tyranny, or did it emerge before that?
Well, it'd probably be very hard to pinpoint exactly when people, and it probably was very different for different people. You know, there were more conservative people who were inclined towards the patriot position who didn't come to that conclusion until very late. And for others, they were very eager to embrace that conclusion. So I don't know. It would be hard to say that there was any one particular point. I think it's more something that evolved gradually, and by 1775, when you see Jefferson's summary view, for instance, is notable for its rhetoric and its the language it uses is much more combative, and it's very clear that by that time he at least is looking maybe to take the conflict to the next level.
You quote John Adams. It's a beautiful quote. I just read the first three lines. Man could write. America will never allow that Parliament has any authority to alter their Constitution at all. She is wholly penetrated with a sense of the necessity of resisting it at all hazards. There's no ambiguity in what he wants. That's a confrontational language, and Adams understood it that way. Is that correct?
Right, for sure. And I'll paraphrase the last part of that quote too. I think is very important because he says right we're talking about British meddling with the constitution of the colonies. He says it doesn't really matter to us whether it's for the better or the worse, right? They could hand us a much better constitution, and we would still be objecting to it, even if it was far better than what we had, because it's not about the substance of what they're doing. It's about that question of authority. It's about who actually possesses this authority, and he says that's what we're really angry about. It's not. It's not the substantive matter, although they were upset about that too. It was this claim of power where there wasn't rightful authority. So he says, even if we're perfectly happy with the outcome, we would still be objecting to this because the underlying principle that power has to be bounded by constitutional authority that was animating them.
Did Parliament respond in a fashion individually or singly or in groups that indicate that it understood the objection and was sympathetic, or was it always just folded arms and a frown on its face?
Yeah, different. There were factions in England that were much more sympathetic to the colonists, but there was a lot of sort of folded arms and kind of looking sideways because I think to a lot of people it didn't make sense because to a lot of people they felt like this was the British Empire, they're British subjects, and Parliament in England, the experience in England was somewhat different. Ever since 1688, when you had the Glorious Revolution, one of the main principles of that was that Parliament, as the representative assembly, emerged as sort of the sovereign authority. And so they saw Parliament as being representative, and so there were problems with that, of course, because the colonists, of course, didn't send their own representatives there. But the from the English perspective, to a lot of people, it did seem unreasonable because you Parliament needs to be able to guide the empire in particular directions, right? They need to be able to have uniform policies. They need to be able to raise revenue when they fought a war and so forth. So I think there was a lot of sort of folded arms and lack of sympathy, but there were certainly some very sympathetic members of Parliament. What the most famous one is probably Edmund Burke, who is famous for other
Right.
reasons and for another revolution, but he was very sympathetic to the Americans.
Article 1 of the Constitution, John quotes for us usefully. All legislative powers herein granted to, including the power to lay and collect taxes, duties, imposts, and excises to the Congress of the United States. That's the House and the Senate, the Congress of the United States, to lay and collect taxes, duties, imposts, and excises. April of 2025, Liberation Day by President Trump and his administration. John, I'd never seen such a contrast as you pulled off in this essay. What have we seen happen ever since what appears to be Congress's power usurped by the executive?
Sure. Well, connecting to the conversation we had earlier, my point in the piece was to contrast the zealous defense of institutional power and constitutional arrangements that the Patriots had with, I think, a relative disinterest with this question of, well, regardless of what you think about tariffs, who is supposed to be doing this? Who's supposed to be making this decision? Where is that power authorized to be exercised? And so, of course, President Trump invoked a law, the International Emergency Economic Powers Act, in which Congress had delegated some of its authority to the executive. So some of its authority to lay and collect taxes and duties and imposts to the executive. Now, how far that law was meant to go is an active legal question. President Trump definitely interpreted that law very broadly because it does say that there needs to be, I think the language is urgent or emergent concern
This is the
that the president is responding to. It has to be a true emergence situation.
this is the
So
Emergency Economic Powers Act of 77 you're referring to, John?
yes, yes.
All right. Please continue.
But at least under President Trump's view, he's invoking that law, which grants the president the power to declare an emergency and then place limitations and regulations on American trade. So it's part of, I think, a broader trend in American politics, especially across the 20th century, in which Congress has preferred, oftentimes for reasons of efficiency, to delegate its legislative authority to the executive branch, sometimes saying the president must declare an emergency to use it, sometimes not. Sometimes Congress will just delegate its regulatory powers or something to an executive branch agency. So I think it's part of a broader trend and a tendency where Congress increasingly doesn't really want to make the big decisions in national politics, but instead grants that authority to the executive branch. And so in this case, we have maybe a very broad reading of the piece of legislation on President Trump's part, but at the very least, he can point to this law that Congress says it is taking that legislative and taxing power and handing it over to the executive.
Perhaps it's the clarity of your prose, but you convince me in reading this piece that there is a revolt in the land of the arbitrariness of these decisions being made day by day at the White House, almost as if we're waiting for the king to speak each day to know whether Jerome Powell is in or Jerome Powell is out, whether China is to be taxed at 150% or 3,500%. And it isn't the Congress that's objecting. The Congress is in the role of, if I follow your analogy, well, if I follow my imagination of your analogy, the Congress is acting like Parliament, crossing its arms and frowning at us for objecting at the where's the rule of law? Do I overinterpret your essay, John?
Uh, it's in that way, I would say right now, Congress's reaction is a little bit of folded arms in that same way. Yeah. But I think at the very least, in 1770s or 1760s, 1770s, Parliament was much more active. Parliament was the one driving a lot of the controversy, whereas today, increasingly, I think Congress, by and large, is happy being passive on a lot of these things. You see, there's very few. Under our constitutional structure, a lot of the framers of our constitution sort of assumed that the people who are in each institution, the person who holds the presidency, the people who are in the Senate and Congress, would be very jealous of their own authority, and you would have this natural tension between the branches of government that sort of holds each one in check. But increasingly, for maybe a number of factors, a lot of that has eroded, especially for Congress. They have a lot of incentives to sort of just sit back and let the executive take care of things and let the president take care of things. So in that sense, I would say it's different in that today, our president is, perhaps ironically, our president is a much more active in personally deciding things than King George III ever was. Right? He was much more of a passive player, and Parliament much more of an active player. Which again, I think there's an irony in that, given how we understand our revolution.
April 1775, April 2025, 250 years. And irony's adequate, John, but I would say it's come full circle. John Grove is the editor-in-chief of Law and Liberty. That's lawliberty.org. This is CBS Eye on the World for Civitas Institute, Civitas Outlook. I'm John Batchelor.